long as that's going. Just want to make sure, I presume people can hear me. That's the weird thing about being the moderator, is that you don't have the same sense of the audience out there and seeing people.
Do we get to see is there a gallery we see?
No, that's the interesting thing about it.
Okay.
I can see a list of participants, but
Molly Patterson Lundgren says,
thank you, Molly. And I assume you can also see us.
Got it.
So that's good. Well, great. Thank you, Molly. Molly's down in Rochester.
Thank you, Molly.
A terrific colleague to work with. So
I just want you to know that the economic development coordinator from our host city, Stillwater, Tim Gladhill, is on the line. I see him as an attendee.
Yeah, that's great. Tim also attended some of the specialized training sessions that we had for the HPC staff and commission members. So I'm really glad that he was able to participate in that. Well, I'm going to give it just another minute in case people are kind of coming back from lunch break, and then we'll get going.
You just kind of watch them parachute in. We're 17 we're up to now.
As I said, a lot more people checked the magic box when they registered and said that they would be attending, and my experience is that fewer of them actually show up, but people are busy.
Yeah, we're all a little Zoom fatigued, I think.
Yes.
So,
which is why I tried to stretch out the conference over multiple days rather than pack, 6 sessions or 7 in the same day. Well, enough small talk. I guess we'll get started. So, welcome everyone to the 41st annual statewide Preserve Minnesota Conference, and this session on effective code enforcement of problem properties. I am Mike Koop with the State Historic Preservation Office. I'm the Certified Local Government Coordinator and the conference organizer, and I will be moderating this session this afternoon, so I'm glad that you are all with us. And I want to start out by reading a land acknowledgement that our office prepared. So as we begin, we want to recognize that Minnesota history spans at least 13,000 years. The vast majority of that time is represented by American Indian history alone. And from that perspective, our urban and rural built environments are very recent. The state of Minnesota, as it's been known since 1858, is within the ancestral homelands of the Dakota and Ojibwe peoples. The 11 tribal nations in Minnesota are our partners in advocating for recognition and protection of the state's historic and cultural resources, along with other Native nations with historical connections here. The State Historic Preservation Office is currently in the final stages of completing our statewide historic preservation plan for the next decade. Among other goals, we seek to broaden the scope and equity of historic preservation through identification and historic designation of more properties important to tribes and underrepresented communities, including traditional cultural properties, cultural landscapes, archaeological sites, and buildings and structures. We encourage you to be part of this effort, to work with us and others to build partnerships and advance preservation efforts across the state. So a couple of logistical items. Just want to mention and remind folks that this session is being recorded. It'll be available for on-demand viewing sometime after the conference. We will send out an email about that to all the registrants. And we have set aside time at the end of the presentations for Q&A, and we'll try to get to questions as time allows. To ask a question, I think most of you are familiar with this, just please use the Q&A function. And now I'd like to introduce our presenters, Joe Van Thomme and Chris Nelson, who are both attorneys with the Eckberg Lammers law firm, which is located appropriately in Stillwater, our host city. I'm going brief on the introductions because if you want to learn more about Joe and Chris's professional backgrounds, you can find their detailed bios and contact information on the Minnesota SHPO conference homepage. And with that, I am going to turn it over to Joe, who will start off the presentation, and I need to give him permission basically to become presenter, and I have done that. So hopefully, Joe, you got it.
I got the little bubble that said I am now a presenter, so we'll put up my. All right. And Michael, can you see? Can everyone see that?
Nothing yet. It might
Okay.
take a second. Still nothing.
Okay. Oh. The button
I like
needed to
that
be
laugh.
pushed.
That's usually the laugh of, okay,
There.
I think I just realized my flub.
Yeah, let's put, so I'm sharing this screen.
Yep, we're seeing
A
window,
blink. Yep.
sunlight streaming through, and there it is.
There it is. All right, so everyone can see that. Good to go. All right, so we will get started here right now. Welcome everyone. My name is Joe Van Thomme, as Michael indicated, and along with me is Chris Nelson. As you can see on the title screen, I am a city prosecutor, a municipal prosecutor. We prosecute for 19 cities across Minnesota in a variety of capacities. Chris is a civil municipal attorney, a city attorney as they're known. In the same capacity, cities all over Minnesota, we represent and help solve problems related to code enforcement. Some of you are probably sitting there thinking, I hate code enforcement. We love code enforcement because it is such a problem and headache for our cities, our partners that we work with, that it presents us with an opportunity to help them solve those problems. So that's really what this presentation is about, code enforcement for cities. I've given this presentation to cities across Minnesota and our clients and help them figure out what the best way to attack code violation and code issues that come up in all of our communities. So we will get started. First thing, we're going to talk about what we're going to cover with code enforcement. Code enforcement, whether you look at it from a civil municipal aspect and using civil prosecution, or whether you look at it from the criminal prosecution aspect, it really is the tools and the principles are very, very similar, and making sure we follow those is really going to be the key to effective code enforcement. So what we're going to talk about are the types of code violations, the things that everyone encounters. We're going to talk about the keys to gaining compliance, as well as the specific tools, a few of them at least, for enforcement. Because the goal of every municipality, if you were in person, I'd be making you all raise your hand right now. But we're not in person, we're on Zoom. So hopefully you're all writing down one single word. The hint was on the last page. The goal of every municipality is compliance. We want compliance. Those of us that work in the municipal realm, municipal law realm, we've all encountered those battles with those persnickety residents and property owners who believe that the city is heavy-handed and out to abuse their rights and those types of things. And we all know that that's not true. As a city attorney, I know that's not true. As city staff and officials, you know that's not true. The goal of the municipality is not to mess with people's lives and private rights and all those types of things that get raised. It's compliance. We want you to comply with the code. That's the goal. And that's what effective code enforcement, the goal is as well, is to gain compliance for our cities. So let's talk briefly about the types of code violations that we're talking about. And as Chris will allude to when he gets to the civil portion, Chris will tell you the type of violation you're talking about can matter, and it can limit or help you choose what the best civil tool is. It will also help you choose whether or not criminal prosecution is the right tool as well. So obviously we're talking about nuisances. We're talking about nuisances related to animals, whether it be barking dogs or whether it be chickens or whether it be I have one city, one of the attendees right now I know may recognize a city where we had horses getting off the property constantly. Those types of situations, trash piles, junk cars, landscaping issues, your nuisance type violations. And again, these lists are not all inclusive. Building code, property issues related to whether it be siding or electrical or different things that are out of compliance. Zoning, home occupation, use violations, whether it be industrial use or whether it be different things that are going on the property. Those are the biggest types of violations that you're going to come across when we talk about code violations. And again, these lists are not meant to be inclusive, just as examples. So let's take a look briefly. And Chris, actually, just so you know, Chris, although we're colleagues and friends, he critiqued my pictures and said I've seen much worse. So the pictures, let's look at a few pictures of problem properties that you may encounter. And some of you, if you're looking at this and saying, hey, I recognize that city or that property, good for you. This is every property. We always get these pictures sent to us of junk all over. And this, you can see this house is more of a building code. There's some issues immediately. You can probably see around the windows and the doors that are going to draw the ire or the attention of your city code enforcement official. Code violations. This is more my rah-rah, win one for the Gippert type speech about why we take action. Code enforcement and cities, the people who deal with code enforcement for cities, it's important to remember why you do this. It's very important to remember that what you do is a livability issue. What you're doing this for is to help people have vibrant, safe neighborhoods. Our firm's motto, our firm's mission is building and strengthening communities. And that means helping them prosecute their crimes, helping them solve their civil issues, helping them have strong, vibrant neighborhoods. That's what code enforcement officials do. Because code violations impact the quality of life. Some of these pictures that you'll see, you may look at it and may say, oh, that's not the worst I've seen. I can tell you firsthand that some of those pictures are of infestations, where children are getting bugs inside their bedroom and getting bitten by animals in the house because it's an infestation. It's a quality of life issue. Property values. If you've ever lived next to a condemned house, you know it makes things very difficult when you go to sell your house. It makes things very different. So it's property values. It's public health and safety. Your neighbors, if you've got code violations related to whether it be dogs or dangerous dogs or animals or trash, it can be a health issue, a safety issue. Community acceptance of ordinances. There was a longtime city attorney in my office who is now retired, Mark Vierling. And Mark actually did this presentation with me for several years, and he added this last piece. And as a young prosecutor, I thought, what are you putting that on there for? I didn't see the value of it. But having done this enough, I now understand that one of the reasons we take action as cities is to make sure that we don't have to take action. Because if we can say, here's a violation, and we addressed it, and we were thorough, and we were consistent, and we followed our own process, that means everyone will accept that, yes, this is what the ordinance says, and I should comply with it. So this last one is actually very important to remember. We take action so that the community respects the ordinance that we have passed. So there's a broken window. This is the infestation picture that I'm talking about. They pulled back the tile to see that there was a cockroach infestation in this house. Chris asked me, he said, well, what is that? I said, Chris, we got to get you out to more condemned properties. This is a major plumbing and mold issue in a house over a kitchen cooking area. And this is just your run-of-the-mill junk pile. We've all seen those. So again, the keys to compliance, the things that we're going to talk about, these are the most important things. If you take away nothing else from this presentation, it's these 3 principles for compliance. It is process. Developing a process that you will follow in every single case. Having a process to follow. Having documentation. And this will be big for both civil and prosecution because they're different for both. Documentation. And then notice and action. Making sure that you are transparent in giving notice to the person who is causing you a headache, to the code violator, but also following through and taking action. You know how difficult it is to have those conversations with people who are violating the code. It's important to not only give them notice, but also follow through. Otherwise, it will get so much worse. So, talking about the keys to compliance, starting with process. The first thing that every city needs to do, big, small, otherwise, the first thing is designate a code enforcement official. A code enforcement official. This person can be, Chris, you've worked with a lot of cities. What are some examples of who your code enforcement official might be?
Zoning administrator, building official, and of course, police officers.
And Michael, just before we move on, can we confirm that we could hear Chris, right? All right, perfect. I didn't know if I needed to unmute him as host. Perfect. Yeah, it's Chris is exactly right. It's a variety of people. In some cities, it is your law enforcement officer. Some cities, it's your community service officer. Some cities, a lot of cities, it's zoning. It might be your building official. These are people that are going to have a working understanding of the code and be able to generally look around and say that's a violation and that's not. So you're going to designate a code enforcement official who takes complaints and observes violations. The issue, Chris mentioned a law enforcement officer, and as a prosecutor, I love law enforcement because they're trained witnesses. They know what to look for. They know what to document within the criminal law. The problem and the limitations you may have if it's a law enforcement officer is that they're not always familiar with very intricate code provisions. And so it usually requires a building enforcement or building official to educate them a little bit. So it may or may not be the best person to have a law enforcement officer be this person. In fact, in most cases, it's probably not. It's going to be somebody within your city staff. But this person is going to take complaints. They're going to observe the violations. Our firm, when we work with our cities, we have a training that we give to councils. You guys can put this feather in your cap and share with your councils as good tip. Your code enforcement official observes violations because unless your city council members want to be a witness in a case, they should not be observing violations. I know city councils love to be helpful and responsive to their constituents, and so sometimes they feel like they're being helpful when they go out to a resident's property and make observations. And then we as a criminal prosecutor or a civil attorney who's enforcing an action have to then call that person, and it gets a little uncomfortable. That's why it's critically important that you have that code enforcement official who is being your witness. Have them be your witness. Your city councils, if they have a problem, send out the code enforcement official. Let them be the witness. Code enforcement official is going to identify specific codes violated. I cannot tell you how difficult it is to move forward with a case in court when you have to relearn the code yourself. Not that we don't know the code, but to have to teach yourself the code because it wasn't identified in the first place. That is very difficult. Judges don't look too kindly on that if your witness hasn't done it for you. You're going to document violations, including photographs, written descriptions, dates, and names. Is it starting to sound like a police report? It should be. As a prosecutor, that's the level of formality I want. I want names, dates, who, what, where, when, why, photographs, time-stamped that say on this date, at this time, I, Sally Johnson, observed a violation at this property. The violation was in violation of code 123.ABC, and here's how it was violated. That's the level of detail. You're going to sign complaints, affidavits, warning letters, or violation letters. Again, when we talk about process, one of the things within process is consistency. So this is going to be the same person from start to finish. You're going to observe the violations, take the complaints, you're going to document them, and then when things need to go out, you're going to be the person that signs them. You're going to identify and maintain a record system. Chris probably has more experience with this than I, at least to the different types of, there's one, I think it's called Permit Works, is one that some cities will use. I don't have a specific system in mind. I would just caution anyone from using an Excel spreadsheet. as your record system of violations and addresses. That can be very, very sloppy and hard to use later on. So turning then to our second, talking about our record keeping system, we're going to talk about what documentation looks like. We've talked a little bit about it, that you're going to document and record specific violations. And as we said, the location, the owner, along with proof. You can't just say John Johnson lives there. Maybe John Johnson's just staying the week and he's the guy you see this week. You have to find out who the owner is, because that's the person who's responsible for a violation. Dates of the violations, specific ones observed, and who you are, who's making that violation. And that will be important when you get to trial in a criminal or civil case. We need to call a witness who made the observations. It's also really important to make sure that there are communications that you have with the owner or the violator. So if you go out and you talk to that owner, and from the road you can see clearly that there are violations, and the owner comes out and says, hey, what are you doing here? I'm just storing my 15 cars out here, leave me alone. That's going to be an important admission that I want as a prosecutor or a civil attorney. I want in the file that the owner admitted to me he has 15 vehicles on the property. That's going to violate most city codes that I know of, at least. Maybe there's some that not, but that's going to be important. So always documenting that, the communications you have with an owner. Again, identifying and maintaining that record system, it's going to be key. Your documentation is going to be very key. And you'll see shortly when we split up and talk a little bit about criminal versus civil enforcement, because your documentation, it's going to be admissible in court in most cases, but in very different ways and for different reasons. So it's really important that you have a nice, concise, thorough, detailed documentation system. Our last key principle for our keys to compliance is notice and action. And it's tempting to break these apart and say notice and then action, but they're really one and the same. It's telling somebody we're going to do something and then doing it. So giving them notice that you are in violation, and here is your process. If you do not do this, you will have this result. This is perhaps the most critical part of code enforcement. It's the reason that it's so difficult to do, I think, is because not every violator will look, act, and sound the same. Some of them are hostile from the get-go, and you know you're not going to get compliance. That's pretty easy to tell them, here you go, here's your notice, we'll see you in court. But some of them are people who maybe have a lot of different challenges, mental health, physical disabilities, things that prevent them from being in compliance. Doesn't excuse the compliance, but it might justify it. That can be a little bit difficult to follow through on. And I'm not suggesting that we go too hard after the little old lady who's got a violation on her property, but also recognize that if you don't take action when you've given someone notice, we're all probably thinking right now of all the voicemails that will pile up in your voicemail box from the neighbors who are saying, well, hey, why isn't she getting ticketed? Why aren't they cleaning up that property? It's going to be hard to tell them, well, because she's a little old lady and I'm not going to enforce the code. That typically won't work. So notice and action, critically important. The code enforcement official, they're responsible for notifying the property owner of violations in person and or in writing. Sometimes in person is difficult, let alone in a COVID world, but in writing of specific violations with code section, dates, your timeline for compliance, as well as the enforcement action that will result if they don't follow through. Critically important. If your city's policy has decided, you know what, if we've got grass that isn't mowed, it's a week. You have a week to clean it up. Then that letter better say you have 7 days from the date of this letter to fix this issue, or we will blank. Whatever the result is, a criminal citation will issue, or a abatement action will issue, whatever it might be. Very critical that you do that. And then taking action, obviously, is day one, you give the notice. 14 days later, somebody better drive by that property and confirm that there is a violation or not still. And again, obviously, talk to your criminal prosecutor. If you believe you need to get inside the house or onto the property to confirm or deny a violation exists, talk to your attorney about whether or not you should enter that property without some sort of warrant, whether it be a search warrant, administrative search warrant, or criminal search warrant. And then lastly, follow the same process for every violator every time. I know I just said I'm not going to be heavy-handed on that little old lady with the physical challenges to complete, to clean up her property, but I would really, really caution any city who is going to be an energetic and zealous, not overzealous, but zealous code enforcement municipality. I would really caution any city from granting breaks or granting exceptions unless there is substantial compliance. So for instance, if there's a violation and by day 14, there's still a violation, but they're almost there, that's probably a circumstance where you can afford some breaks. But if there's not, I would really caution anyone from doing that, because the old saying, if you give a mouse a cookie, you will have a problem that grows pretty quickly. So tools for enforcement. There are obviously civil remedies like abatements, injunctions, temporary restraining orders, some mechanisms to obtain fees and costs. There's also criminal prosecution, which is complaints and citations. So let's shift gears, I'll shut up, we'll talk about the civil remedies, and I'd love to hear from the civil side of things. Chris, tell us about civil remedies.
Thanks, Joe. And thanks everyone for being here today and having us here to talk about that. One of the things that is an important distinction between these two is a civil action is an effort to clean up the property, basically, or to get a court order stating that the condition on the property cannot be maintained. It's unlawful and it cannot be maintained. Criminal action, as Joe's going to talk about, is about an individual who's maintaining their property in a condition that doesn't comply with the code, but it is a specific punishment against that individual. It doesn't necessarily lead to a declaration that the property must be cleaned up. So it's important to keep in mind when you're looking at what remedy to pursue, how important it is to obtain an order that states that the property has to clean up. And if you're going to do that, that's really the civil realm of code enforcement. So first thing we have to talk about are abatements, which are a specific form of civil code enforcement that are related to nuisances. And an abatement is a process you can get if somebody is maintaining a public nuisance on their property. It's possible to go through what's called a nuisance abatement action. Now, I think this is kind of interesting. Well, what is a public nuisance? Well, state statute defines a public nuisance as maintaining or permitting a condition which unreasonably annoys, injures, or endangers the safety, health, morals, comfort, or repose of any considerable numbers of members of the public. Well, what does that mean? It's incredibly vague. That could be everything or nothing, really. One important thing to keep in mind is any considerable number of members of the public. Whatever's going on a particular property, in order to meet the definition of a public nuisance, it cannot just affect one person. This has to be something that's affecting a number of people, affecting the community at large. And because the definition is a bit vague, it's important to know specifically what are public nuisances. And to do that, we have to look at statutes, ordinances, case law, which will define what a public nuisance is. There are some specific provisions, for example, gambling establishments can be public nuisances. Places that routinely serve to minors can be public nuisances. All those are spelled out specifically in state statute. But when we're talking specifically about today on property cleanup, maintaining junk cars on a property is something that can meet the definition of a public nuisance. Maintaining junkyards where there's the possible infestation of animals, meets the definition of a public nuisance. If there's down trees or trees that are blocking passage on sidewalks or streets, that qualifies as a public nuisance. So the real question is it affecting a considerable number of people, and is there an ordinance, statute, or case indicating that this is a public nuisance? And if it is, then you can potentially proceed with an abatement action. And
Chris,
so this,
if I can ask, it sounds almost as, I mean, we talked about the documentation piece. Is it your experience then that not only is it, finding out what the nuisance is, but then it sounds like it's critically important that there be detailed documentation about the facts, about this is the issue and here's who it's affecting. That seems like it would be pretty critical for an abatement action then.
absolutely, I think that is critical, and for any type of enforcement that we're talking about, documentation is key. And as Joe's already explained, given the individual an opportunity to clean it up. And that's actually what's required in this abatement process. You have to provide written notice. We've talked a bit about notice, but a written notice of the violation, summarize what the evidence is of the violation, and notify the property owner that if they fail to abate, there could be a complaint filed in court. At that point, if a property owner doesn't abate a public nuisance, we can go about filing a civil complaint, which is a lawsuit. And then there's going to have to be a hearing on whether or not this qualifies as a public nuisance, and potentially get an order to clean up the property. Or if it's a building specific issue, the building can remain vacant pursuant to court order if there's an issue with the building itself. But in the junkyard example, where we're keeping property unlawfully on a property, if it's junk boats, junk cars, things like that, in order to remove that property from the parcel, you need to get an order authorizing the removal of that, and that's what an abatement order is. One of the advantages of this is it's possible to assess the cost back on the property itself. So in this type of enforcement, it's possible that the property owner would have to reimburse the city or local government authority for the costs incurred in cleaning up the property if the city is forced to do that.
Chris, one of the things I think a lot of, at least, and I have a limited experience on the civil side, a lot more on the criminal side, but that is a common question I get. And I'm curious to know, we have that first notation, the timeline. What is the timing of the abatement? And as cities select how they want to proceed, I think one of the things they're always going to consider is, well, how quickly will the problem be solved? Well, what does that mean within the scope of abatements?
Abatements, you have to give somebody 30 days to clean up their own property, and at that point you can proceed with a case. Abatement cases are typically a little bit quicker than ordinary civil cases, but the process really isn't going to start for 30 days if they fail to clean it up. And then when we talk about a more informal notice that Joe was talking about earlier, it might add on a few more days to that, and then you give the formal abatement notice, and then you file a case. So I mean, realistically, when we see that timeline there, I think that's fair to say how long it would take. But an abatement case is generally quicker than what we're going to be talking about next, which is a general enforcement, civil enforcement case. So in a case where you have an issue on a property, code enforcement issue on a property that doesn't qualify as a public nuisance, or even if it does, you want to pursue another remedy, you can start a civil action. Just like any type of lawsuit, there's a complaint, the use of this property or the conditions existing on the property violate state statute or city ordinance, and we're asking the court to make an order preventing continued use of this property in this manner. And that order forbidding the use of the property in this manner is called an injunction. And so when we're doing a civil enforcement case outside of the abatement realm, outside of the nuisance realm, typically we're pursuing an injunction, which is a court order saying the property cannot be continued to be used in this manner. Now, this is a standard civil lawsuit, and sometimes we can go for temporary relief, early relief. In the case of a temporary restraining order, the term you see up there, that's something that can be granted almost immediately after a case is filed. But in order to do that, it's a pretty substantial showing that there's an immediate harm that needs to be remedied. You know, one example of that could be if, for example, there were sewage forming on a property. That's something that you could very likely get a temporary restraining order for, because there's no immediate irreparable harm, risk to public health caused in that situation. If it's, for example, a setback violation, somebody's in violation of their setbacks under the zoning code, you're not going to be able to meet that requirement. There's an imminent immediate harm to the public. So that case is going to go forward, and you're going to have to prove that case, because you're just not going to get that standard on a setback violation. So how long these can take really can depend on what we're trying to enforce. If somebody has been maintaining a shed unlawfully on their property, well, that's not really causing an immediate injury to anybody. So that case might take a while in order to prove that. It's not a nuisance, so we can't proceed in that fashion. But you know, it's not an immediate harm to the public, so we're, you know, unlikely to get an injunction, a temporary injunction, or a temporary restraining order requiring removal fairly early on. So that can take a while. One of the situations we might see, and one of the situations you see, particularly in historic districts and communities, these are places people like to spend a lot of time. There might be old houses. They're starting to be used as Airbnbs. This might be unlawful. The community might not permit Airbnbs, might not permit Airbnbs in the historic district. Or if it's a party house, it could be creating a lot of noise and problems that way. Noise can be a nuisance if it happens multiple times. So we could take a look at that. But if we're trying to gain compliance with a business, for example, that's maybe functioning or has been functioning for a while on a property unlawfully, that's something that would be a lawsuit where we'd be trying to enjoin further use of the property in that manner. And an important part here when we say costs and attorney's fees can be imposed. And in abatement action, there's a specific statutory provision saying that a prevailing party can win attorney's fees. So it's possible that costs can be paid for by the property owner. Here, it's simply uncertain. Attorney's fees are, if there's a statute or rule indicating that attorney's fees can be imposed, it's possible attorney's fees can be imposed, but oftentimes if there's no specific authorization for attorney's fees, this will be a cost paid for by the local government. So it can be pretty expensive to, for example, try to enforce setback violations, for example.
Chris, what about the timeline on the difference? Because between an injunction or TRO or a civil complaint, as you described, a lawsuit, versus an abatement, it sounds like this version, this tool on the civil side, is more for those immediately apparently hazardous, or as you said, irreparable harm type cases. Is that a fair statement, or what? How does that impact the timeline for this type of a tool?
If there's an immediate irreparable harm situation, you know, getting a TRO is the quickest possible thing you do. You file a complaint, you file a request for a TRO, a temporary restraining order, and you can get that order fairly quickly if you meet the threshold. For a case that doesn't have immediate irreparable harm, these can drag on for quite a while, 1 year to maybe 18 months. So that's something that local governments have to consider when they're thinking about enforcement. And somewhere in between the two is an abatement action. So.
Yeah, and I asked that because my experience with the civil side enforcement is a few injunction type cases, and those were always cases where there was an immediate public health. You're talking about sewage, or you're talking about some sort of noxious chemicals or something that is a real problem. And if we don't do something now, it will get worse. And the example, we filed something, I think it was a Thursday morning, and the judge had signed it by Friday morning. I mean, that's what we're talking about, those cases where immediate action is needed. So that's something to talk about with your city attorneys about. We've got an issue, we need to address it, and they should be able to tell you this is the tool based on the harm. If it's something that's immediate and needs to be done and taken care of, a TRO may be your best answer.
Yeah, that's such an important point, that the type of harm, the type of violation, the remedy or the process that we use to remedy the situation is unique to the harm. So just an overall scope here of things to expect. Time for civil enforcement of code enforcement. Depending on the type of harm, it can be long. If there's an immediate harm, immediate risk to the public, you're likely to get quick enforcement. If there's not, this can take a long time. Costs. Local governments need to be prepared to pay costs of this unless they can point to a specific statute that allows them to assess the costs back to the property owner or get an award of attorney's fees. The biggest advantage of civil code enforcement is that if you're able to get an order stating that a property cannot be maintained in the manner it's being maintained, or if an operation cannot continue on the property, that's a permanent solution, and it's a comprehensive solution. That act or that condition will no longer be permitted on the property. So if you get an injunction against a illegal junkyard, you go in, you clean it up, that can't be maintained in the future, and then you'll very likely have the right to go in and do it again if somebody starts accumulating that junk again. But it does provide the most comprehensive result, because it's an order about how the property is maintained as opposed to an individual punishment.
And that's exactly, that segues into the other main tool that cities have, which is criminal prosecution. But that phrasing that Chris just used is really, really important. The property or the condition can't be maintained. Civil code enforcement is about the property. It is about the property and attacking the condition that is on it, and either eliminating it or doing other approaches so that it can't continue in the future. And that's really what civil code enforcement is. And that will impact, again, as Chris said, when you look at whether criminal enforcement is appropriate or not versus civil enforcement, because criminal prosecution is really focused on the individual. It's focused on the individual, and there's a variety of ways to think about that, but it starts with the Constitution and the rights that a criminal defendant has. So the reason criminal prosecution is even available is because state law allows cities to designate ordinance violations as misdemeanors, and most do. That's a good, easy cleanup tip for a younger code enforcement staffer to look at your code and decide, are there fixes we can make? Do our codes that we want to be enforced, do they provide penalties? And if so, what are they? A lot of them will say it's a petty misdemeanor, which under Minnesota law, a petty misdemeanor is a fine. There's no probation, there's no ability to do really anything with it other than give somebody a fine. And for your more entrenched code violations, sending someone a fine for up to $300, if they don't, they may pay that and say, great, my property's still a mess, what now? So it might be something to look at through your code and do a review and say, are there things that we could do to beef up and strengthen our codes so that we at least have the option to do criminal prosecution? Because state law will allow you to do it, but you have to spell it out as the penalty being a misdemeanor. And a misdemeanor penalty is 90 days in jail, a $1,000 fine, or both. That's state law. Now, I want to pause there on that for a moment and just caution, put a big picture, 30,000-foot view of a penalty in a misdemeanor case. For those of you that read the Metro section of the Star Tribune a couple years ago, the city of Orono had an enforcement action against a property owner there, and the defendant, the owner, was put in jail. And I don't recall if it was through a trial or a plea or something, but he was put in jail for 5 days. Not 90, not 60, not 40, not 10, 5 days. And it made the front page of the Metro section. My point in bringing that up is not that that was a good or bad result, but that type of a penalty on a code enforcement case drew the attention of the biggest newspaper in the state of Minnesota. So I say that because while there's a penalty potentially of 90 days in jail or $1,000 fine or both, it may be very unlikely, depending on the circumstances, that you would get anything close to that. And if you do, you should be prepared that the public appetite for that type of penalty may not be there. So just a word of caution that that's a potential penalty. It's not likely that it's going to happen in a code enforcement case. Criminal prosecution is started by complaint or citation. Citation, usually a county citation issued by a sheriff's deputy or a law enforcement officer. If it's initiated by complaint, still should go through law enforcement. At a minimum, your prosecutor is going to need very similar information that you would need for your civil complaint, which is details about the violation, who observed it, when they observed it, what the violations were, and then what code is violated. That's going to be needed to charge a complaint. Now, criminal prosecution, the process. As we talked about, the constitutional rights afforded to a defendant are what guides us here. Complaint or citation is filed or issued to an individual defendant about the defendant's actions related to that property, not about the property itself. So that gets issued to someone, says John Johnson has 15 cars on his property, and he's got a failing septic system, and he's got broken windows and all of those things. It's about John Johnson's failure to comply with code, not so much about the condition itself. So the process would go is the citation or complaint is filed. You then go to an arraignment. An arraignment is a fancy way of saying, here are your rights. You have the right to an attorney. You have the right to a trial. You have the right to remain silent or testify, and no one can comment against you. Yeah, blah, 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 all the way down. All the rights you hear on TV, that's pretty close to what they tell them at arraignment. At that arraignment, they have the right to an attorney. They can get an attorney. And that further complicates things. I shouldn't say complicates, that's their right, but it further changes the dynamic of how the case is going to move forward. It then gets set for a pretrial. And I will tell you that in a pandemic world or not, you usually don't have one pretrial. You usually have many pretrials for a variety of reasons beyond the control of your prosecutor or the court system. Sometimes people get sick and miss court dates. Sometimes people ignore court dates. Sometimes people need more time to get an attorney. All of those things can lengthen out the process and the number of hearings that you might have. And then finally, you'll get to a trial, if you're lucky. And I say that not because your prosecutor won't try. We've tried cases on the civil side of things. We do our best to get that trial to court, or the case to trial. But you also need to understand that when you choose the tool of criminal prosecution, you are choosing the threat of jail time as an encouragement or enticement to that property owner to fix the property for you. The threat is dependent on my ability to prove the case to a judge or a jury. One of the constraints on that is obviously going to be there's only so many judges, there's only so many juries, there's only so many prosecutors. And on any given day, there's dozens of cases that are unresolved that need to go to trial. It might be a felony case if you're in a small county versus a misdemeanor code enforcement case. It might be a domestic abuse case versus a misdemeanor code enforcement case. It might be a DWI versus a code enforcement case. One of those cases can only get in front of the jury at a time. And I've just listed out those examples to give you a flavor of it's usually going to be the domestic abuse case, the felony case, the DWI case. Those are the cases that will draw the court's attention, and quite frankly, they probably should, because they involve what are known as person crimes and individual victims of the crime versus a nebulous victim that a code violation can have. So there's a lot of constraints on the criminal process to actually coax enforcement. That said, A lot of cases resolve with pleas, and your prosecutor should be prepared at every hearing to know exactly what the status is. So when we talked about that code enforcement official on the prosecution side, before every pretrial, my practice is I look at the case. What is the most recent communication that we've had with that owner? If we haven't had any, I call that code enforcement official and I say, tell me what the status is. Have you observed additional violations? Is there anything new to report? So that I can go back to that owner at court and say, all right, Mr. Johnson, code enforcement official says you've cleaned everything up except this one thing. How about we work out a plea agreement where you plead guilty, pay this fine, get this penalty, and then you go clean that up within 30 days. And that can sometimes happen. So just because you can't get to trial doesn't mean there's not ways to use the system, but you usually are now digressing into some creative prosecutor work, which I like to think we're pretty creative and effective, but it really depends on a variety of factors. So requirements for prosecution, very, very, very similar. Documents, reports, photographs, evidence, and witnesses. One little caveat to this, where things change from criminal to civil when it relates to the requirements to initiate a case. In a criminal case, there are some rules related to what's called discovery and disclosure. What I, as a prosecutor, have as an ethical obligation and a constitutional obligation to disclose to a defendant. In real people speak, non-lawyer speak, what that means is if you have a case management system and reports and documents about a property owner that says, boy, this guy's a real joke and he's so dumb and man, I can't believe he's doing this and he was all kinds of sloppy, unprofessional stuff. In a civil case, there may be different rules about when and how that gets disclosed. In a criminal case, if it amounts to what's called exculpatory information, meaning information that suggests maybe the defendant isn't guilty or suggests something that would help them prove their case or avoid being found guilty, I have to disclose it. So it's a professionalism question, but it's also can constrain how effective criminal prosecution can be. So that's a big, long, fat way of saying be very concise and detailed and professional in your reports because it may come out somewhere and it may not always look good 3 months later. So what to expect with criminal prosecution? Time. Probably more so than the civil case. We're living in a world right now where cases are getting backlogged because of the pandemic and it's harder to get a court hearing and harder to get a court date. You're going to have to expect time. So to Chris's point about choosing the tool based on the violation, this is critically important. If you have a violation on a criminal case or on a code case that is very entrenched long-term, criminal prosecution is probably not your best bet. A use violation is probably not your best bet for criminal prosecution. Prosecution is great for the barking dog case. It's great for the broken window case. It's great for the they didn't cut their grass for 3 weeks case. It's not terribly effective due to for those cases where it's going to take a lot more of a comprehensive order. So expect that it's going to take some time. And again, knowing that should help you decide whether this is the right tool for code enforcement or not. Control issues. Control issues, this is exactly what I'm talking about. In a civil case, the focus is on the property. In a criminal case, it's on the defendant. And sometimes when you're prosecuting a case criminally or civilly, you are the person asserting control. You are saying, we need control of this situation. We need this person ordered to do something. We need this property ordered to be cleaned up. We need this person to go to jail if they don't do it, or whatever it might be. In a criminal case, the guiding feature is there probable cause to charge, and what are the defendant's rights? Right to a trial, or right to an attorney, or discovery issues, or motions, or delays in the trial. Your prosecutor loses control due to those rights that are afforded to the defendant. Doesn't mean the case doesn't go forward, but it might not always be as direct as we want it. An additional control issue to keep in mind is when you convict somebody in a criminal court, Sometimes the idea would be, well, we get them on probation and we tell them you don't have to go to jail if you clean up your property. Well, you've now just turned over control to the correction system. And if anyone knows of a corrections agent in the state of Minnesota who wants to monitor your city code, please, please, please put them in touch. We're looking for them. They don't exist. Corrections will not monitor your probation violation. They will not go out to the property to ensure that person is compliant, not while they are making sure that felons take drug tests and people don't violate domestic abuse no contact orders. They won't do it. So that's a control issue to keep in mind. It's hard to ensure that someone will keep a property clean through the criminal court system. And that's that comprehensive result issue that Chris brought up. What else to expect? A trip to court. I made a passing reference to city council persons being on witness stands. That's what this is talking about. The whole reason we try to localize it into one single person or one single department is because you will need to come testify in a criminal case. The defendant has a constitutional right to confront his accuser. That means you've identified them as violating the city code and therefore state law. They have a right to confront you in court. So if it gets to trial, you should prepare to come to court. Now, your prosecutor should also help prepare you for court. So I'm not saying that to freak anybody out, but just understand that that's part of the process. You should also expect that success can vary. In a criminal case, they have the right to a jury trial. In a jury trial, the state has the burden of proof beyond a reasonable doubt to convict somebody. They also have to convince every member of the jury. Not just one, not just two, not just a majority. Everybody has to agree that the defendant is guilty. I will tell you that I have tried lots and lots of cases. I've won most of them. And the ones that you've lost, you cannot for the life of you figure out why. And every so often you'll get a chance to talk to a jury and it'll be just very strange reasons of why they acquitted that person. And it could be as simple as, my dad had a code enforcement case once and I didn't like the way the city treated him. Oh, but you thought he was guilty otherwise. So it just can be anything. So that's both a control issue and also a success can vary issue. You certainly can lose on a variety of reasons. So it's something to keep in mind that it's not a slam dunk. It never is, but certainly not on the criminal side. So civil remedies versus criminal prosecution. Remember, civil remedies can typically be comprehensive. They can be costly depending on the length and time invested, and the focus is on the property. Criminal prosecution is quicker to initiate. It can be less costly, but also less effective, and the focus is on the person, the individual violator. So let's turn to a civil case example. Chris is going to tell us about a civil case.
Well, and being aware of time, I'll move quickly, but I just want to highlight the fact that the quicker the case is likely to move, the more likely the case is going to have some ramifications on public health and generally. So in this particular case, we had an issue with a septic system that was causing problems on a residential property, and complaints started coming in. After that, it was determined that an action was needed, and so a complaint was filed. That lawsuit was initiated with a request for a temporary restraining order. That temporary restraining order, because it allows for immediacy, was granted. And then after that, they're entitled to a hearing on the terms of that and the underlying issue, because a temporary restraining order is temporary. You still have to go about proving the case. So we did have the hearing. The judge ultimately issued an order continuing the restraints on it, and then ultimately the septic was cleaned up in this case, and it is generally an illustration of how code compliance can work. Once the septic's cleaned up, the case is dismissed, so we don't end up going to a full-blown court trial on this matter, because the goal of compliance, as Joe highlighted from the beginning, was met. So fairly quick turnaround on this. Pretty good example of successful civil code enforcement. So
One of the things I find fascinating in the world of code enforcement, and again, this is a prosecutor who deals with, as a portion of the many, many cases we prosecute, code enforcement as a small portion of them, but we do them regularly. That said, the phrase that jumped out at me was emission from subsurface raw septic effluent. Didn't know what that meant until I saw the pictures, and it's a little bit like Old Faithful in the worst way, is what this case was. And when you see the pictures and you realize that, oh, that is raw sewage from your failing septic system right onto the property line with your next door neighbor where little children live and dogs live. That's a problem. So these are those cases that you're talking about where a TRO is really, really the right way to go. Now, I will say that the complaints were coming in, but their ability to confirm that what was happening, you had to wait till the snow melted, unfortunately. And so they were able to finally do that. And it really was a pretty quick turnaround. I mean, you're looking at April to July with less than, a week or a week and a half of time between the septic system was shut off. Now, there was the hearing, but prior to that, there was a TRO. And then they had a formal order that said it's turned off, not just the temporary relief granted. That's a really quick turnaround to tell someone living in that house, you can't flush your toilet, you can't turn your water on, you can't take a shower, you can't do your laundry until this is fixed. So it can be very, very effective, but it's really dependent on making sure everybody's ready to go. And in this case, we had a great system and we were able to move forward very quickly.
and the type of harm. If it's a public health harm,
Absolutely.
more likely to be dealt with quickly.
Absolutely. And then the stipulation by dismissal, as you talked about. All right, turning to the criminal prosecution case example. We've seen some pictures from this already. This was a case that I handled personally. It was in a housing development, and this particular, there was the Minnesota Department of Health was involved. They had received complaints from the tenant. It was actually a fairly sad case in the sense that it was a non-English speaking family, and the person who contacted the Department of Health was the teenage child who spoke English and said, there's bugs in our house and my little brother is getting bit and we don't know what to do about it. The landlord won't do anything. So it could have been a TRO type case, but the appetite locally was there was zero tolerance for, as they called them, slumlords. And so they wanted us to initiate a complaint, a criminal complaint. So after taking the time to make sure that we had detailed reports, it took about 2 weeks. The reason it took a little bit more than 2 weeks was this is that whole point of making sure that your case file is complete. We had to go back to the building enforcement official and have them spell out, hey, your photos say, they say that this is the property. How do we know that? Oh, it's because I took them. Great, put that in your report. When did you take them? This date. Put it in your report. So there was a little bit of back and forth to make sure that they put everything in place. And then we could file the complaint because you have to have that all in your complaint. So we received the complaints, we received the reports, the violations were observed and confirmed. About 17 days later, the criminal case was filed. There was an arraignment hearing, as you can see, filed it at the end of October. Takes at least a month to get a court hearing. Meanwhile, the violation's still going on, just so we're all aware. That's what criminal, there's no ability for me to order anyone to do anything unless they've been convicted. I can't order the judge, I can't ask the judge, order this person to not have any violations. Can't do that. The judge only has jurisdiction over that person, not the property. So December 9th, we have our arraignment. April 11th, we're talking 4 or 5 months later, they give you a pretrial court date. That's Criminal Court 101. It's just when the court has availability to hear that criminal case. Another pretrial hearing because this person was getting an attorney. I will tell you that at this point, we're now 6 months out as a prosecutor who knows the goal of my city, who knows that the victim is hopefully making some arrangements to not have to deal with this on their own because, again, in criminal, you cannot get an order yet. I'm having conversations with the defendant at this point. I'm saying, look, I need to be two-pronged about this approach. I need to have the trial track going forward so that the threat and pressure of a trial is hopefully stimulating this defendant to go ahead and complete the process, or and all that pressure part, track one, also while telling them, look, let's talk about a resolution where maybe you comply and you decide to solve the issue for us. So that's what ended up happening from between April 25th of 2016 and September 12th, or August 1st, excuse me. There was a plea of guilty to one of the many counts of code violations that he was charged with. And there was some terms that we said, look, we're going to give you a chance to clean this up pending sentencing. So now you've pled guilty, and one of the terms is go clean it up, and we'll come back and see how things look at sentencing. So that defendant ran with it and came back. There was a reinspection and compliance was confirmed. And so then we came back at sentencing. Everything's been cleaned up. I think the defendant got some sort of unsupervised probation and a fine, but the point was it worked. It eventually worked. In this case, we did not represent the city on the civil side. We represent the city as criminal prosecutors. I will just tell you that I don't know that there was a candid conversation about the immediacy of the threat on the civil side, and I have only so much ability to help engender that conversation. So I said we can charge whatever you need to. Just know that these are the limitations. And so we did our absolute best to get things taken care of. And thankfully, things were cleaned up eventually. But that's sometimes why it's a good idea. You know, if you have an attorney that does civil right down the hall from you on represents the same city, you can have that conversation, that comprehensive conversation that say, well, do we want to send it to Joe or do we want to send it to Chris? How quickly do we need this taken care of, and what's going to be the time frame and the cost? So, successful code enforcement. And I want to make sure.
Oh, and Chris, can I just interrupt for a second?
Absolutely.
It looks like we have about 8 minutes left. I'm not sure how much of your presentation is remaining.
Very little.
But I just wanted to make sure we allowed time for any Q&A.
Absolutely. I was just about to say that. I would just real quick here. So, to
Thanks.
recap our principles of successful code enforcement: process, having a process and following it, making sure that you document what you are doing and doing it in a professional, thorough, and detailed way. And then notice and action, giving notice and following through on that promise, that threat, following through that if you don't do this, we will do that. So can it work? This is a property. You can see some of the building violations. There's some rotting boards at the bottom. There's some missing shingles and siding. Same here. There's also, on the other side, there's a broken window. You can see there's missing handrails and steps and different things going on. Now, Chris wasn't so impressed by the before or after, but I thought the house looked fantastic, comparatively speaking. So the answer is yes. Yes, it can work. It absolutely can work, but it depends on partnering with your city attorney and your city prosecutor to choose the right solution for the right problem. So it can work. So that's what I got. So Michael, I don't know, how do we do questions? I probably need to stop sharing, right?
Well, I see a couple in the Q&A. I can read them out, if that sounds good.
Yeah, go ahead. Go ahead, Chris.
All right, the first question is, most HPCs in Minnesota are municipalities, but we also have commissions that represent townships and counties. Who would be designated as the code enforcement official in those instances? Well, in that case, it depends on whether or not the township has a zoning code. Towns can enact a zoning code, or they can rely on the county code. If they're relying on the county code, it's very likely that the official may be with the county. If the township doesn't have staff, for example, but if the township has their own zoning code, they necessarily have staff, and it'll likely be the town administrator who will be, or the town clerk who will be the code enforcement official if there's a town zoning code.
Great.
And then the second question is, did we cover administrative citations as a tool for civil enforcement? And no, we didn't. And the answer to that is probably because it's really just good faith that the person will enforce it. Administrative citations will lead to fines. They can lead to potentially repeated fines, but you're never going to get an order in an administrative citation enforcing the code. So an administrative citation could be effective in more minor cases, but if there's a use violation, a long-term setback violation, things that are more substantial, I don't think administrative citation is likely to be too successful because it's really a fine and good faith compliance.
And that goes to, I think, one of the things. That's exactly right, Chris. We don't focus on it a lot because if the whole premise of an administrative citation type approach is that, well, people will get scared by that fine and they'll just take care of the problem. If that's good faith you're relying on, I'd rather have our city staff work with residents before we have to even issue fines or anything. And those people that are going to be good faith are going to do it without the threat of an administrative citation anyways. The enforcement part, unfortunately, when it gets to a point where you need a criminal prosecutor or some sort of civil action taken, you can fine them 100 times. It's not going to make a difference. You could probably charge them with the citation. It's not going to make a difference. It's the process, the drawn out process of a civil action or a criminal action that's eventually going to turn that over. So we really don't focus on it because it's just in our experience, you know, I've prosecuted for 19 cities. Chris has done almost as many civil cities. We just don't see a lot of traction with it in a way that's worth advising you to do.
And the third question here is, for a city to collect costs and attorney's fees in civil enforcement, must the right to collect be set forth in state law, or can it be a city ordinance? Typically, attorney's fees, if they're ordered, there needs to be a law allowing that attorney's fees are ordered, or a state case indicating that. With regard to city ordinances, I'm a big fan of robust city ordinances, particularly in the nuisance realm. So you can at least get those costs and potentially assess them back to the property. So as we talked about with public nuisances, it's pretty loosely defined. It's not really a very specific definition, but the city has the right to go beyond that and make specific declarations about what are public nuisances within its city limits. And then it can have a robust abatement ordinance that can assess costs back onto the property, the cost of enforcement, which can be potentially some of those legal costs. So I'm a fan of comprehensive public nuisance ordinances if the municipality is interested in compliance. So I think that runs through our questions. I don't know if anybody has any others, but those were the ones in the Q&A. So
anything else, Michael? Anyone else?
I don't see any other questions either, and I don't see anything in the chat, but fantastic job. Thank you both, Joe and Chris. And again, the session was recorded. We also on the website have email contact information for both the speakers. So if you guys, any of the participants, want to follow up directly with them, please feel free to do so.
Absolutely. Please do. Please feel free to reach out with any questions. We're happy to be resources to you and all your cities.
Well, I think we're just about at time. I actually have to run because I'm moderating the next session, one of the next two. So I am going to go ahead and close the recording on this and close the session.
Ms. Howard just asked a question. Ms. Howard, you can email us if you'd like. I don't want to keep Michael waiting, but if you have a question, you can certainly email us.
Thank you,
It looks like
everybody.
it was, yeah, just a thank you. She said it was extremely informative.
Got
So
it.
thanks-
You can still
thanks,
email
Barbara.
us if you want.
Well, thanks again, guys, and have a good afternoon.
You
Take
too.
care, everyone. Thank you. Good luck.